Hi, International IP class. This is Professor Opterbeck, and just welcoming you to another week. I can't believe we're already rolling into our fourth week. So once again, good job in the forums last week. I noticed that a lot of you, in talking about the work for hire doctrine in these different jurisdictions, really focused on the question of fairness, which I thought was very interesting. From the American perspective, we really focus on primarily an economic concept, which I suppose, given the way we view copyright law and international or intellectual property law in general, is really not surprising. And one of the things I was kind of referencing in talking about that economic view was an idea about the theory of the firm. And one of the economists who's written about this is Ronald Coase, and there's many others, of course. But this sort of Coasean theory of the firm is the idea that a firm, a corporation, or other sort of business entity is organized into a distinct legal entity in order to reduce transaction costs. So instead of having individual contracts between each employee and each manager, you subsume all of that into one entity, the corporation or the firm, or whatever other form of corporate organization it might be, and that entity has contractual relationships with all of the employees. So it's not so much of a web, but a sort of central hub with spokes. And the idea of the American work for hire doctrine, you could see in economic terms as really another step in that sort of Coasean idea of the firm, that we're eliminating those transaction costs. You don't have to negotiate that license agreement at all. The law says the firm owns the work. And then what you negotiate between the firm and the individual employee is salary and benefits and things like bonuses or other things like that, if the employee in fact is doing work that would be considered copyrightable. The European view does reflect, I think, a little bit more of that sort of fairness or really moral rights kind of perspective, that the individual never really fully is giving up their control over their work to an enterprise. And so if the enterprise wants it, they've got to negotiate a separate license for it. It's also a different view, as I mentioned in the video, of the firm. Many of the continental European views of the firms is as a much broader social entity. So I'm not necessarily suggesting one view of the firm is the right view, it's just different kinds of perspectives. I also found it really interesting that many of you thought that the Chinese model was the best model, and I suspect that you probably didn't come into an international IP class thinking that you would say, I think the Chinese policy here is actually a good one. So I thought that was interesting, and a number of you did, even those of you who did favor the Chinese policy, a number of you suggested that, well, maybe the 2 years is not long enough, and you'd have to think about those sorts of terms. So all of those things, really good discussion. You'll see when we get to patent law, there is no work for hire doctrine in patent law at all, even in US law. So in contrast to copyrights in US law, for patents, the employer does have to negotiate an individual license with each employee if the employer wants to own any patentable inventions that the employee might come up with, even in the course of employment. And that usually is handled in industries like, say, pharmaceutical or high-tech computer type industries, with employment agreements that include a pre-invention assignment. So it is still kind of handled up front, but it requires separate agreement. All right, this week we are going to be moving into another segment of our copyright discussion. As you see, as you're going through the materials, I mentioned in the video, it seems like some of what we're talking about, this Ariel case and this receiver Sevier case don't really fit together, but I think the overarching theme is how the internet changes or not concepts of copyright, or at least how the internet challenges concepts of copyright. In a way, I think that's also true for the Kirtsaeng case, although that is an old technology, a physical book. One of the questions it kind of raises is this idea of international exhaustion relevant anymore, or is it even more relevant given that the internet crosses borders? So just kind of keep that theme in mind as you go through the week. And I hope you have a great week, and I will see you online.